The last to argue was Loretta Pettit on behalf of Harris County, Texas.
Thank you, Mr. Chief Justice. And may it please the Court. In the last 15 years, this Court has rejected at least 3 times that an officer's otherwise lawful conduct violates the Fourth Amendment because an earlier split-second decision made a confrontation more likely.
What was at question in the district court was not a question of making a confrontation more likely. It was the reasonableness of jumping onto a moving vehicle and using that as a pretense for using lethal force. After all, expert testimony on behalf of Officer Felix showed that he shot so quickly, Ashtian Barnes did not have time to stop.
Properly understood, what Judge Higginbotham dubbed the moment of threat doctrine merely applies that rule. As this Court recognized in cases like Mendez and Sheehan, it is necessary because the Fourth Amendment must be applied by thousands of real cops in the real world without, in the words of Kentucky against King, an unacceptable degree of unpredictability.
So thousands of real cops cannot understand that escalating a situation may bring the reasonableness of their actions into question, but millions of gun owners are required to. It seems the entire argument of the respondents is to place law enforcement above the laws they enforce on the American people.
The moment the officer-created risk theory, which petitioners have continuously pressed at least until their reply brief in this court, is antithetical to that proposition because it invites an open-ended subjective inquiry into the officer's intent that cannot be conducted without the benefit of hindsight. It also, as Mendez recognized, involves tricky questions and fuzzy standards of causation that cannot be easily applied.
Nowhere has anyone asked to look at an officer's intent. In fact, Mr. Zielinski specifically stated that such subjective analysis was not their intent, but the objective analysis of the reasonableness of the officer's actions.
Because the Fifth Circuit has properly rejected that proposition, its judgment should be affirmed, and I welcome the Court's questions.
Because the Fifth Circuit gave them the answer they wanted, Officer Felix in Harris County, Texas, want the court to stop there. But would that be justice? Would that be due process, a judicial process designed to protect the legal rights of the individual? I don't think so.